It is 8:41 right now. Welcome back to the program. Lou and Jackie here.
Good morning.
And look who has joined us. It is Michael Jankins. How are you, sir?
Doing great.
Great. Talking the world of bankruptcy. And this morning, I think you're really going to teach us a whole lot.
Well, today we're going to talk about some bad things that can happen in some people's bankruptcies. And fortunately, it's not for most people, but from time to time, it can occur. So everybody goes and files bankruptcy because they want to essentially escape the burden of their debts.
Right.
However, on what I would call rare occasions, some of those debts file a lawsuit against the person in the bankruptcy.
So it's not an automatic for in 100% of the cases.
So it's not automatic, and and this usually arises because the person's conduct before going into the bankruptcy proceedings was less than honorable. So in those situations, the creditor, other than just being mad about the fact, like all the creditors are not getting paid, they may have been defrauded.
I was going to say, how do you break that down? Because in all circumstances, they're not paying what they're supposed to be paying, so they're already not creditable. So how do you break that down? And is that what's called an adversary complaint? Yeah,
this lawsuit that gets filed against a person in a bankruptcy is known in bankruptcy terms as an adversary complaint.
Okay.
So it's basically you're being sued in your bankruptcy to have to pay the debt.
Okay.
Now, is this a matter of just being cocky about it, or is it a matter of being confrontational? What's the bottom line here?
It's usually for a person's conduct going back sometimes 6 months to a year, or maybe things they did even before that leading into the bankruptcy. And so to begin with, there's a deadline. If you want to file one of these lawsuits, it's got to be filed during the time the case is open. So we've talked many times about when the case is initiated, notices go out to everybody about the fact the bankruptcy has been filed, and there's a creditor meeting that's going to take place about a month later. Well, on that notice, there's other deadlines too. And one of the deadlines says the last day for filing of a complaint. And as it so happens, that last day is also the day after is when your discharge is granted, where you're given a clean bill of financial health. Most of your debts are eliminated. So you have until that deadline date to file this lawsuit. If you file it one day late, you're out. So these are bad things. They can go from a really big debt to sometimes your entire bankruptcy. So there's generally two types of complaints.
Okay.
Under Section 523 of the Bankruptcy Code, the complaint or lawsuit is just by a single creditor asking the court not to let the person out of that one debt.
That specific debt.
Just worried about themselves.
So it's just worried about themselves.
And why would that come up in certain circumstances?
Well, there's usually fraudulent conduct or some bad actions that occurred between the person filing the bankruptcy and that creditor.
Okay.
And we'll kind of split those down in a bit.
Okay.
The other kind of complaint that can be filed is not just for one of your debts not to go away. It's basically to kill your whole bankruptcy, not to allow you to have a bankruptcy.
Wow. None of them.
And so none of them. Although a creditor can include that as part of their complaint, I've always felt I didn't really see that it was a good strategy, because if you have one aggrieved creditor who wants to get paid or work something out, it usually, in my eyes, isn't a good idea to also make another count saying, and we don't want this person's entire bankruptcy to go through either, because then all the creditors would have a shot at trying to go after the person.
Okay.
And so then no one's going to really get much money at all.
You think the business would just worry about their own account, not worry about everybody else?
Well, that's what I've always thought, but maybe they think that they're scaring the person more somehow. But those are pretty tough claims to win, and usually those are called 727 complaints. Those are under the Bankruptcy Code section, and more often than not, those would be brought by a government agency called the United States Trustee. Okay. And most of the time, not always, but that's for bad conduct that's either gone on during the bankruptcy, which isn't good to have happen, or an inability of a person to account for their dealings leading into the bankruptcy, their financial dealings, keeping records and things like that if asked to produce them. Mm-hmm. So that's a sweeping denial of a bankruptcy, and we're going to kind of focus on just what an individual creditor can go after on their claims. So the first one I've got in my outline here is Section 523 of the Bankruptcy Code. So there's a laundry list of different kinds of claims that wouldn't go away, but we're just going to focus on a few where somebody has to file a complaint for these. So the first one's under A2A, and that is for debt or money or property or services that were obtained essentially by fraudulent conduct, making false representations, false pretenses about how you're going to get these things. It can also apply to renewing the credit, extending the credit. So the typical complaint that just filed under this thing is with credit cards. The theory is when you're trying to charge your credit cards, you have an intent to pay it when you're doing it. That was the plan. You charge and you pay.
That's the original agreement.
That's the original agreement. Well, the case law developed that if your conduct leading into the bankruptcy was so reckless where you don't have, it's clear you don't have enough income to pay these things, and you're just charging away going into the bankruptcy for 3-4 months, thousands and thousands of dollars. You don't have the ability, you've got $40,000 of other credit cards that you can't pay, and you just can't even make these payments.
So reckless abandon.
They're just saying you have made false representations of your intent to pay these things. Clearly, you were just running them up with no intent to pay. And so credit card companies will use this as their basis to ask that, if not all of the particular credit card debt of that American Express.
Do we have any statistics on how often they win a case like that? No. Okay.
They're not brought that often anymore, and I believe, at least when I would have them, we would settle them if they were just slam dunks and my client just was kind of using poor judgment.
Right.
And very few of them that I actually have a trial on. There's usually not enough invested in the balances to really have a full-blown trial. But they don't do these that often. There was a time where they were filing quite regularly.
Is there any monetary amount that they would wait to go after? Like, was it 20 grand, 40 grand, 60 grand?
Well, no, on one card, I mean, you know, if someone charged up $5,000, $6,000, $7,000, you know, 2 months before the bankruptcy, that would be something that they might be looking to get some money back.
But also important why you need a lawyer and someone who knows what's going on to help you out. Okay.
Now, the second one that's under the same section, but subsection B, deals with written instruments where you basically made false statements about your financial condition, and you have to show that the person relied on those false statements and that it was an intentional act. So this is something that's usually brought by lending institutions, and primarily it's going to be for people that are operating businesses or farming operations, which are businesses. And in those cases, every year, most times, a business or the owner is supposed to submit a financial statement, or when they actually even first get the loan, everybody's got to submit a financial application to get the loan. And you got to put all kinds of information about your stuff and list your assets and other debts that you got. Put values to the stuff that you got, because in making a decision, should we lend money to this person? Well, in all fairness, banks, you know, usually rely on those things. Should we give the person a loan, and will they be good for it? Is this good collateral we're going to be taking? And if you lie, then they can bring a complaint against you, again, for bad conduct on your part for lying.
So if you doctor the numbers so you get the loan, for example, that could come back and bite you.
Or if you, you know, some people think a little exaggeration's okay. Well, no, there's a difference, I would say, between a little exaggeration and just complete misrepresentation.
Flat out lying.
I mean, valuation, opinion about value of assets can be in the eye of the beholder, and there certainly can be you know, a fluctuation on what it could be worth, but you know, at some point it's just an outright misrepresentation. And if you say you've got something that you own on your statement when in fact you don't really own that thing, well, that's a bad thing too. And failure to disclose other debts that you've got, even though they run credit reports, because sometimes something may not show up. Again, that's just conduct that can get you into trouble. And when you sign these things, it's kind of a good idea to read the language under the signature line that says you're doing this under penalty of perjury, and that this is the truth, and that we, the bank, are relying on what you're telling us. So that can result, if you misrepresent your situation, they can file something in your bankruptcy saying, you shouldn't get out of that debt. And it can also apply to refinancing the debt, or if they extend your loan for another 12 months based on lies, that's bad stuff, and bad conduct gets you bad results in your bankruptcy.
Got it.
So it's really good to deal with people on an honest basis, and most people do, and that's why these are relatively rare based on the millions of bankruptcies that are filed.
Right.
These do come up from time to time, but a very small percentage.
So bottom line is don't lie.
Bottom line is don't lie.
Live an honest life. I think that's a good thing we can all live by this morning. But if people need some assistance, and obviously you know how to handle this, Michael Jankins, how can they get in touch with you to make sure things are handled the proper way? You
can call me at 255-1855. You can find us on the internet at www.iowa-bankruptcylaw.com, or you can follow us on Facebook.
There you go. Thank you, sir. Good to see you again. Have a great day. It is 8:51 right now. And we really quickly want to take a look at traffic with the situation. Once again, dealing with the situation that has your right shoulder blocked on the Northeast Mixmaster. And this is if you're traveling and coming off of I-3580 down to I-235, heading towards downtown. This is what we've been warning you about, but wanted to give you an exact visual. So affecting traffic coming in on the top side of the metro on I-3580, down on I-235. And of course, if you're coming in Altoona or Ankeny, also affecting you, as this is all kind of coming together at the Northeast Mixmaster. We'll keep you up to date on what's happening with weather and traffic right here, being your only live and local program on until 10 a.m. right here on CW Iowa Live. We will be right back.